Uh, I am immensely gratified and have esteemed pleasure in welcoming Honorable Shri Arvind Datar, a designated senior advocate, to this August gathering of the budding group of lawyers of the Nainital High Court, the Vasudev Law College, the fellow professionals in the legal and accountancy fraternity, ladies and gentlemen, who are fortunate to hear the icon of law and the legendary of taxation, constitutional law, direct indirect taxes, Shri Arvind P. Datar. Shri Datar is a prominent senior advocate and a finest lawyer from the southern India. He is a cost accountant and has graduated from Bombay University and has attained his law degree from the Government Law College, Madras. He is an expert on constitutional law, company law, direct and indirect taxation, bilateral investment treaties, environment law, mining and intellectual property rights. His writing of Nani Palkiwala, the courtroom genius, is the most praiseworthy piece of workmanship portraying the legendary Sri Nani Palkiwala. Amongst other legal commentaries, journals, to mention a few, Guide to Central Excise Law and Practice, Datar's Commentary on Constitution of India, and his painless efforts in revising the edition of Ramaiya Guide to Companies Act, Ganga and Palkiwala Law and Practice have been the legends of the books that he has given to this generation. I have a deep reminiscence of late Honorable Sir Sri Nani Palkiwara, who had addressed us sometimes during 1976-77 when we were undergoing the BCom honors course in DAV College, Dehradun. He started his he started his speech by saying, "Read or starve." He said that when he was undergoing the law profession, he had a 6 by 8 study cum bedroom, and in which he used to work tirelessly and effortlessly for at least 20 hours a day. And when he has to feel tired and go to bed, then he has to again wake up and start painting all the walls. And his parents had to, after every 1 or 2 months, had to repaint it because, but he said that all the motivation and his struggle helped him in achieving his goals. Uh, I was so impressed by his motivational speech that I took up the taxation profession and undergot the chartered accountancy profession. And during the profession, the his books, Kanga and Palkiwala, and the book's Guide to Central Excise, which is a very good workmanship on commentary on central excise law and the reforms and the classification dispute, the valuation, the how the changes were made from Modvat era to the Senvat and all others. That helped us immensely in practicing the direct and indirect tax laws. Sir, I would request you that some commentary is required on the GST, and Your Honor has done a lot of work on the side of the constitutional law, the books on the constitutional law, and the, the taxation. Now it is an immense need that something should be done on the GST because it has become so cumbersome for everyone that all the changes are coming day by day. Although the GST was the aftermath of the to reduce the cascading effect and to subsume all these direct and indirect taxation. But that is the requirement of today's, which a lot of guidance is required from Your Honor. Your Lordship Your Honor has been an amicus curiae and has assisted the courts on various questions of constitution and taxation laws. The benchmark judgments today, in which Your Honor is going to debate, is the S. Puttaswamy 9-bench judgment on the right to privacy. To name a few, Kane Energy, which is a bilateral investment treaty arbitration before the arbitral tribunal in Hague, Abhiram Singh, a 7-judge Supreme Court judgment in which reference is made to whether religion in election campaign is corrupt electoral practice. Navjit Singh Johar, a 5-bench judgment of the Honorable Supreme Court concerning the homosexuality under Section 377 IPC. The Supreme Court advocate on record a five-bench judgment which has struck down the 99 to 2015 amendment creating the National Judicial Appointment Commission. Jindal Stainless Steel versus State of Haryana, which is the nine-bench judgment on the constitutional validity of entry tax. The Union of India versus R. Gandhi, which challenged the constitutional validity of Chapter 1B and 1C of the Companies Act Amendment Act 2002. Sahara India, Real Estate SEBI, concerning the commercial and regulatory disputes are a few amongst so much hard work and labor and benchmark judgments which have been achieved by you, sir. Sir, I thank you and that you have spent uh, your valuable time and precious time in addressing this legal fraternity, who shall immensely gain by the knowledge and abilities and shall be a motivation and inspiration to the audience to achieve their goals in the legal profession. Last, I would sum up the words of the great poet Henry Wordsworth Longfellow, who said, "Lives of great men all remind us we can make our lives sublime and departing leave behind us footprints on the sands of time." Over to you, sir. Thank you.
Well, thank you very much, sir. So just a few words on behalf of, sir. Thank you very much, sir. Sir, before just a few words on behalf of High Court Bar Association, my Honorable Secretary, Mr. Saurav Adhikari, over to you. And thereafter, we'll start with the session, ma'am.
Am I audible, Sakti ji?
Go ahead.
Okay. On behalf of High Court Bar Association, Nainital, Uttarakhand, welcome Shri Arvind Datar ji, Senior Advocate. Sir, it is a great privilege and a legal luminary like you is between us. We are also lucky, and sir, as the today's session of privacy, this new dimension of right to life has made fundamental right more meaningful and declares law in glorious terms. Sir, we are quite too keen to listen you today. Today indeed is an opportunity for all of us, as our guest is a legal judge. Thank you, sir. Once again, we all are highly grateful to you to spare time with us. At last, sir, I would say, sir, हाई कोर्ट बार आपका बेसब्री से इंतजार कर रही है, सर. सर, एनी टाइम आप आइए, सर, और हमारी बार को कुछ सिखाइए, सर. Thank you so much, sir.
No, thank you, sir.
Yes. Good morning to all of you. I can see so many young friends there. Welcome to all of them, especially. These are the future of the bar. These are the Nani Palkhiwalas and the great people who are sitting in the audience who will one day come to the top of the profession. I must thank Shakti Singh for inviting me to have this lecture on behalf of the Nainital Bar Association. So pending for quite some time. I had to, I think a couple of times we had to cancel it for some reason or the other. And finally I said that I must complete it before the end of 2023. Unfortunately, I could not travel to Nainital, although this is one place which I have not visited and I would like to definitely come. And as Mr. Adhikari mentioned, if I'm coming with my family, I'll definitely make it a point to visit your High Court. Justice Sirpurkar, I think, was your Chief Justice for some time, and he used to speak very highly about the bar. It's a very courteous, very, very nice bar, and he said you must visit the High Court once. So I promise I'll try to come next year or in 2025. I'll definitely visit your court. Now, when I asked Shakti Singh what would the audience like to hear, because more than me speaking, it depends on what you want to listen from me would be important. And he said that the bar would like to listen to a short talk on the right to privacy as decided in what is known as the Puttaswamy case, particularly because I had the occasion of being one of the seniors who appeared in the matter. Now, this is a landmark judgment of 9 judges. It is not very often that a bench of 9 judges is constituted, but this was constituted. And then the first question comes, why was it referred to 9 judges? Why not 5? Why not 7? So what is the reason for it to be referred to 9? That is the first question. Now, it so happened that when the Aadhaar came, first it was by a mere executive notification, there was no act. And then there was also a mandatory requirement that we link the Aadhaar to the PAN card. So I appeared before the 3-judge bench and then 5-judge bench in this case, which we challenged that why should Aadhaar be linked to the PAN card. Of course, the court held against us, even the 5-judge went against us. But on the general principle, Aadhaar was basically for essential subsidies. If you read the Aadhaar Act, it is only for targeted subsidies. The idea is that if you've got an Aadhaar card, if it's an identity, like a social security number in the US, then the benefits can go to that particular person. You can identify who is Mr. Arvind Datar, who is Shakti Singh, who is Mr. Malik. They got your thumb impression, because two ways of identifying a person, either thumb impression or your iris, the eye. These are the unique features of a particular person. And we said that, look, Aadhaar is not mandatory. If I'm not getting LPG subsidy, if I'm not taking a ration card, if I'm not doing it, why should I be asked to get an Aadhaar card? And in the beginning, people said that compelling me to have an Aadhaar card for everything is violation of a right to privacy, because people started saying that. I remember in one case, a lawyer from Delhi, when his child wanted to be admitted in LKG, they said, give the Aadhaar card to the father. When other student wanted to go for board examination in 10th standard, they said, where is your Aadhaar card? So we said that, look, what has Aadhaar card got to do with attending a board examination or something? It is wholly unnecessary. And the argument was, it violates my right to privacy. Why should I give my details to everybody unnecessarily? So at that time, I think it was August 2015, suddenly when the matter was before the bench of 5 judges, the then Attorney General said in court that there is no fundamental right to privacy. It was a very startling statement. He said there is no fundamental right to privacy. All of you are law students, all of you are passed out of law college. Just see part 3, article 14, 19, whatever. The word privacy is not there in the Constitution. So he said there is no right to privacy at all. Where is it? And then he quoted 2 judgments of the Supreme Court where there was an observation that India does not have a right to privacy. You see, in the American Constitution, there is a sentence that nobody can violate a person's home except under authority of law. In other words, your home cannot be searched unless there is a search warrant. And that has been interpreted by everybody to mean right to privacy, that my home is sacred, my privacy is important, and you can't violate my privacy or violate my personal space without a search warrant or without an authority given by a judge. So on that basis, the US Constitution has developed the law of privacy in several ways. But he said there is no such thing in India. Where do you get it? And he referred to 2 judgments, and I just briefly referred to them. One is MP Sharma's case, which is 1954, where a bench of 8 judges, or normally the benches of 3, 5, 7, 9. It's very rare that you have 8 or 6. But this was a case where MP Sharma was 8 judges. Now, what was this case? Here was the Dalmia group, which was at that time under scrutiny for various tax violations, company law violations, and so on. And the Department of Company Affairs wanted to search all the records. They said that you can't search my record, it violates my right to privacy. So in that context, the court said, look, there is no right to privacy. Your records, if they want to scrutinize it for the purpose of checking whether you have violated the law, definitely there is no right to privacy. So in that context, one sentence was there. It had nothing to do with liberty, personal freedom, etc. Just on the case of a search done by a ministerial department, and they said you have no right to privacy. Observation. This is a bench of 8 judges. The second most serious case was Khadak Singh, which is one of our landmark judgments, and I would implore all of you, particularly the youngsters, to see the dissenting judgment of Justice Subbarao. If you are interested, you can note the cases AR 63 Supreme Court at page 1295. 63 Supreme Court at page 1295. So make a note, kindly go to the library and read it today if you can. Khadak Singh was a notorious criminal. He was an accused person, accused of very serious crimes. And because he was under serious crimes, he was asked to report to the police station frequently about his whereabouts. If he had to leave his village and go to some other village, he had to inform the police station where he is going. And suppose he went, say, from Nainital to, let's say, Agra, hypothetically, then he had to report to Agra that he has reached Agra. When he came back to Nainital, he used to say, okay, I've come back to Nainital. They would come to his house at all odd hours. Whoever came to his house was checked and supervised. So this was part of the UP rules, UP police rules. So he challenged these rules and saying that this violates my right to freedom, and right to Article 21 is life and liberty. Life liberty is just not plain liberty of being, but life liberty also means meaningful liberty. Out of 6 judges, 5 judges said no, the rules are valid, but the only one rule the majority struck down was that they could not make visits at night to his house. The visits to the home could not be made at odd hours. So one part of the rule was struck down. But Justice Subbarao, in his classic judgment, he said the whole rule has to be struck down. He said that this is very important. He said just because this man has got a bad track record or the case has got some serious charges against him, should not color our judgment. We should not decide a constitutional right depending on who the person is. Everybody has got the same. And he said, what is the purpose of you constantly being under surveillance of the police? And he used a very classic judgment. He said, if this is the law, then the whole country is a jail. For Khadak Singh, the entire country is a jail. And he said that, look, in England, every man's home is his castle. I've also got the right to liberty, but this is going too far, and he struck down. But Subbarao is in the minority. The majority again made one observation. India does not have a right to privacy. So you have 2 judgments, one in 1954 and one in 1963, which say that there is no fundamental right to privacy in India. So when it came before the Supreme Court in 2015, the Supreme Court had one judgment of 8 judges and had one judgment of 6 judges, which said India does not have a right to privacy. Now, if this law had to be overturned, it had to necessarily go to a bench of 9 judges. And that is how Puttaswamy came before a bench of 9 judges, because one judgment of 8 judges said there is no right to privacy. So if that law had to be overturned, then necessarily you had to go to a bench of 9 judges. Now, in 2015, Aadhaar had just started. By the time the matter came in 2017, 100 crore Indians have been issued Aadhaar card. So basically, whether Aadhaar is right to privacy became academic, it became applicable to everybody, and we now had to decide whether there is a right to privacy or not. The difficulty was arguing was, India has enumerated fundamental rights, Article 14, 16, 17, 19, 21, 22, then religion, 25, 26. All these articles are spelled out elaborately. Is it open to the court to create a right? There is no right to privacy. Where do you fit in this right? And when we argued the case, the court asked us, where is right to privacy? Is it in Article 14? Is it in Article 19? Is it in 21? Where do you put this right? And then we argued that the right to privacy, just because it is not defined, you can't say that there is no right to privacy at all. It is in Article 21 definitely. It is in Article 19. It is in Article 14. But the Supreme Court went one step further and said it permeates. It is throughout Part 3. That's an important point to note. The right to privacy has been held to be spread all over Part 3. And they said this is a core constitutional value. The right to privacy is a core constitutional value. This is the view taken by the Honorable Supreme Court. Now, before I come to this, it is interesting to first note a few judgments of the US Supreme Court as to how the law is developed. In the US also, there is no word right to privacy, but the courts have developed the right. Now, we first go to one judgment in the Supreme Court. At one time there was prohibition in the Supreme Court, and a person was going to a phone booth to make calls. The phones were tapped. He said that you're tapping the phone without a warrant is violating my right to privacy. You can't tap my conversation. The state argued, we never asked you to go and speak. If you're going to speak and commit illegality, the police are definitely entitled to follow your conversation and tap your phone. That was struck down. The majority upheld it first. The minority, Justice Brandeis, he said no. He said that, look, science and technology is going so rapidly that even what you speak in your bathroom can eventually be recorded and known to the world. So we have to be careful. We should think of the law, what will happen 10, 15 years ahead. And he said that unless there is a proper search warrant, an authority by a court, you can't tap a person's conversation. Later on, in the case of a person who was into gambling also, his phone was sought to be tapped. And this time the court said, yes, you can't eavesdrop, you can't tap a conversation unless there is a warrant issued by the court. So this is the development of the law. First they said, no, there's no right to privacy. But after 1940, they said, yes, there is a right to privacy that's protected. Now this was further developed. For example, in different cases, the US had very funny laws. As late as 1965, in some states, you could not sell contraceptives even to a married couple. That was challenged. The US Supreme Court struck it down saying that, look, use or not to use contraceptive is an individual choice. A couple may not want to have children, so you can't. So that law was struck down saying this is your decisional autonomy. Your right to decide whether to have a child or not is your child. The court cannot interfere. And surprisingly, till 1972, you could not sell contraceptives to an unmarried couple. That also law was struck down. Later on, one more case came where a person was arrested for having pornographic magazine in his room. That was challenged. Then the court struck it down saying, what you do in the privacy of your room is entirely your business. As long as you're not violating anybody else's right, this should not be disturbed. So this is how the law in the US developed from time to time. Now, as far as India is concerned, I'm of the view that it was wrong to say that we did not have privacy before the Datar case. In fact, I had done some research and I found that in 64 cases, the Supreme Court had used the word privacy. And I'll just give 2-3 examples as to how privacy was used even before the Datar case. First case I'll mention is the case of Selvi, which came from Tamil Nadu, where, there is something called truth injection. They can do narco analysis. They can give you an injection and have a lie detector test to find out whether you are speaking the truth or speaking the lie. The theory is that in a particular state, when you're conscious, you can hide the truth. But under the influence of this particular injection, it is believed that whatever you say will be the truth. So this is an injection given to you, and then the court records or the doctor records what all you say. Now, it's debatable whether it is working or not. But the Supreme Court said you cannot compel a person to take the lie detector test. It is up to him to say yes or no, and therefore they struck down this mandatory injection which can be given, and it was completely struck down. The other important case is where there was a lady. Can all of you hear me? Is
Yes,
there
sir.
difficulty in the...
No, sir. Sir, please go ahead. Absolutely fine.
Yeah. In the other case, very interesting. There was a lady who was unmarried and she had a child. And when she went to apply for a birth certificate, they insisted that they put the father's name also. She said, I don't want to put the father's name. The child of the father is a married man. He's already married. He's happy. I don't want to disturb his life. What has happened, I have got no complaints about it. I wanted this child is my child. The matter went up to the Supreme Court. Initially, the lower court said, when you apply for a birth certificate, you have to give the father's name. It is a rule. That is the law of the land. You have no choice. But when the matter went to Supreme Court, they said this is a matter of informational privacy. It is up to the woman to say, disclose or not to disclose who the father is. It is her choice. And they struck down similar rules in 28 states of India and said, tomorrow if you're a mother, you're unmarried, or even if you're married, you don't want to disclose the father's name, it is your choice. You can keep that father's name blank. It need not be on the passport also. That was a great development. That is a matter of informational privacy. The first case of Selvi, narco analysis, was a case of bodily privacy. I'm entitled to protect my body in such way I want. You can't. Then these are the two cases. But there is one interesting case where the Supreme Court said the right to privacy is not absolute. It is subject to restrictions. It is subject to public interest. And a very interesting case again from Madras. There was a person who came from Northeast, came to Chennai for treatment. He was also engaged His fiancée was also a doctor. He was also a doctor. And during a blood test, it was found that he was HIV positive. He had AIDS. This was disclosed to his fiancée that this gentleman has AIDS. He filed a case saying that you have violated my right to privacy. You have no business to communicate this to my fiancée, and therefore you violated my right to privacy. The matter went up to the Supreme Court, and the Supreme Court held no, yes, right to privacy is important, but your fiance's right to life and health is also important. Tomorrow, if you get married and you have HIV, you're going to infect her, and it's going to cause her possible death also. So just as your privacy is important, it has to be balanced with the right of the other person, and therefore they said that there was nothing wrong in disclosing your medical condition to your fiancé. It need not be put into the press, but it was definitely nothing wrong in disclosing it to a person who is likely to be affected by that information. So even before the Aadhaar case, the Puttaswamy case, the Supreme Court had protected the right to privacy, but this was before a bench of 2 judges, 3 judges. Finally, it was put on a clear pedestal by a bench of 9 judges. And now you can note what are the 3 pillars of the right to privacy. And that is contained in Justice Nariman's judgment at para 521. There are 3 pillars of privacy. First is physical privacy, that is your bodily autonomy. Nobody can compel you to take an injection. Nobody can enter your house without a warrant. Your physical space is protected. That is physical privacy. Second is informational privacy. Information about yourself is extremely important. It can't be disclosed without authority of law. Now that is a very big problem now in the present days of the internet. You have WhatsApp, you have Facebook, you have so many other things. Your information is known. You have Uber, you have Ola, you have GPS. Where you are going, what you're doing can be known. And there is something called metadata, that is data of data. They can collect large amounts of data about you. And that data can give you a profile of your picture. In fact, there was a big controversy in the US called Cambridge Analytics, where by making a surveillance of your phone calls, where you're going, what you're doing, they could make a complete profile, and they could identify that you belong to a Mexican community or belong to this particular community. And this data was used to deny loans to particular classes of people. And that became a huge controversy in the US. Now, for example, in European countries, today if you go to Madras or Bombay, there is a surveillance camera and the traffic signals also. So much of data is mined. It's called data mining. So much of data is collected from millions of people. There is a rule that after 3 months, this data has to be wiped out. That's called road rolling. Government can't keep data endlessly. They can keep it for 2-3 months for sake of law and order, for crime prevention, but you can't keep that data permanently. So what are the parameters of data protection? You've got now the Personal Data Protection Act bill is coming up, where they have said what is the personal sensitive information which cannot be recorded, what can be done, to what extent your data can be given to others. All these are larger issues which will come from the aspect of informational privacy. Justice Nariman has said that, look, if you voluntarily give your information, then there is no privacy. For example, if you're in a Nainital Bar Association and you're given your name, address, and there is a book of the members of the Bar Association, then tomorrow you can't say that Bar Association gives the address to somebody else or the book is available for sale. You can't say that I violated my privacy because you're voluntarily given that particular data. But there's a still big gray area to what extent your data can be shared, to what use it can be done. That is a huge amount of controversy. You see, what happens is, now you get, say, for example, Swiggy or Uber. If you're going by Uber, the company knows from which place to which place you have gone. If they know that you're going to a particular place all the time, suppose you're going to a particular cancer hospital 10 times, they know that potentially this could be a cancer patient. So this can be done by metadata, by analysis of your data. All this will have to be regulated in the near future. But what is happening now is the benefits are enormous of the internet, whether it's Google Maps or Uber or Swiggy, the benefits are enormous. To what extent your data can be compromised is a matter to be decided. And the third thing, so I said first is physical privacy. second is informational privacy, and the third is privacy of choice. That is what is called decisional autonomy. What career I take, whom I marry, what do I decide to do for a holiday. All these are personal informational decisional autonomy which cannot be infringed. This 9-judge bench will have landmark consequences on the future. Now you'll ask me that this judgment has been delivered in 2017. What is its benefit? How has it been applied in the future? One is, for example, recently in 2023, they upheld the right to abortion and reproductive autonomy. They said it's a woman's choice to have or not to have the baby, and this is her question of physical privacy and her decisional autonomy. They said it is a statutory right of a woman to terminate her pregnancy and it's her reproductive choice to have the baby or not. So it has been applied in the case of right to abortion. Now, in the case of Anuradha Bhasin, where the internet was suspended in Kashmir for some time, there they said that information plays a very important part, and if you start restricting information, if you start preventing the flow of information, then again it violates the right to privacy. Information should be known, should be disseminated. Denying a person's information also amounts to violation of privacy. It has a chilling effect. Then the one important case which I had argued also, I was one of the people who argued, was decriminalization of same-sex couples. Under 377, a same-sex relationship was a crime and you could go to jail for a long sentence. The Supreme Court decriminalized it. They read it down to say that if a gay couple decides to live together, they cannot be prosecuted and punished. It is their decision. Who will be your partner, whether it's of the same sex or opposite sex, is entirely your thing. So India fell in line with most of the world where it was believed that there is some kind of mental aberration if a person is gay. Then they found out that 3 to 4% of any population will have same-sex attraction. It is a physiological problem. It's not a crime. It's not something to be ashamed of, or it's not something to be hated upon. It is just a medical condition, like you may have some defect in the knee or you may have some other physical attribute. That's the way. It can't call it as a defect or anything. It's just that one person is built that way. 3% of the population will have attraction for their own same sex. So that was decriminalized, saying that on the basis of the right to privacy. And finally, Shafin Jahan, where a Muslim lady wanted to marry a Hindu boy, they said again, it's a matter of right to marriage is an important part of mental integrity and self-determination. It is your choice whether you want to marry your own religion or outside your own religion. Nobody can, this entire concept of love jihad, etc. was not allowed. And they said that right to marriage will be the right of each individually, man or woman, to marry a person of their choice. So this is what the right to privacy has been upheld. When you ponder over it deeply, you will find that the Supreme Court has done a remarkable job. One point was, what is privacy? How do you argue what is the definition of privacy? The Supreme Court made it very clear, just because we can't define something doesn't mean that it doesn't exist. And therefore they said that the right to privacy is there throughout Part 3. The fact that it cannot be defined, you can't say it is vague. And they have now clarified and made it into 3 parts: physical privacy, informational privacy, and decisional autonomy. So this is the important judgment. It has completely made our fundamental rights more progressive, more meaningful, and several things which could not be done earlier now will be permissible even without an actual constitutional amendment. They have read right to privacy into Part 3. So this is the entire judgment of the thing. So we should be grateful to the Supreme Court for the landmark ruling, and I hope that this judgment will make getting bail, getting freedom, etc. more important. It will also give you more freedom to do what you want as long as it's within the parameters of the law. Thank you very much.
Well, thank you very much, sir, for a very enlightening brief. Sir, now if anybody wants to ask, I have 2-3 questions in advance, so we'll ask to Arvind sir. If anybody wants to ask any question, with the topic, they can unmute themselves and they can directly interact to Arvind sir, if anybody wants. So sir, first, sir, there is a query which in advance.
Opened somebody has opened one hand. I don't know. Go ahead.
So if anybody wants to interact with Arvind sir, you can unmute yourself and you can directly ask your question, one by one.
Very good morning, sir. I'm Rachna Sharma for LLM first year, Vasudev College, and I'm very grateful and thankful for this such an information. So, like you said about the 3 criteria regarding this privacy. So, under the topic of information privacy, I just want to ask if, like we all are on social media, we all are open on social media these days. So sometimes if my phone was hacked or my WhatsApp is hacked or my email is hacked, so there are punishment for those. But is there any separate legislation for such activity?
No. There is one thing on hacking is a contrary to law. I mean, that is completely illegal, and there is cybercrime laws are there. There are issues on what kind of data can be shared, what extent it has been stored. There's something called personal data protection, and that has become a law. Personal data protection is going to be they lay down the parameters of to what extent data can be shared, data cannot be shared. Everything is a privacy policy. Now, suppose you sign up to, say, Facebook, or you sign up to a particular a channel or an app. Suppose you go to an app, then you'll find there'll be a privacy policy. They'll say accept all cookies, accept all privacy. If you go to WhatsApp or you go to Facebook, you have to say I accept the privacy policy. They tell you what are the information they may share, what are the information it may not share. For example, if you go to Air India, for example, or an airline, or you go to Google, if you tomorrow go and search for, say, airlines to Egypt, next day you'll immediately get Egyptian hotels, Egyptian details, and so on. So the machine picks up and knows that you are interested in going to Egypt. So that's called targeted advertising. Instead of advertising to millions of people, they know that Miss Rachana is likely to go to Egypt. So this is what is called targeted advertising. Now, that I personally don't think anything wrong with that. Once you search it on Google, it can always be utilized and you get the benefit of it, you see. And it also becomes cheaper for the manufacturer, for the service provider. They don't have to spend crores of rupees on advertising on front pages of newspapers. They can just focus on an individual person. So Facebook also, suppose you find that, let's say you are looking at a car, say you're going for a Maruti car, you go to the Maruti. So they may tell you which are the other showrooms of Maruti, which are the other models of Maruti will come to you. This is the information used for targeted advertising.
Yes, sir. So one more thing, like we have registered in telecom companies or somewhere in other like informations from our bank records and other companies, like many ways we have deposited our information. But what is the security that person will not transfer our information to other one? Is there any security for that?
Yeah, one is the privacy policy of the bank. Suppose you go to a bank. Now, there the bank will tell you what all the data they're going to share. Also, there is a law which prohibits sharing of personal sensitive information. Now, there are some items, if you see the relevant rules, some items of information cannot be shared at all. Like, say, individual information about you, about the sex, etc. There are some big restrictions have been imposed. So, the law has laid down what can be shared, what cannot be shared. So depending on what is your problem, you can go to the relevant rules. PDP Act is there. The IT rules are there. What can be shared, what cannot be shared. And they will give you a clear idea of what can be shared. There's also now a grievance mechanism. If you feel that your data has been hacked, there's a grievance mechanism. You can go there within 72 hours or 48 hours there to respond to you. And various provisions have been made. Because with all these benefits, there is possibility of the information being shared. Some of it can be shared if you go individually. Many websites like travel agencies, airlines, they make it very clear that their airline will be used for advertising purposes. Or, for example, just see some sites, they say, we want to send you notifications, say yes or no. Now, if you say no, then your phone number will not be used to send notifications. If you say I accept, they will send you all that. So those are the ways where you're given the right to whether you should get more information or not. So to answer your question, you have to see the PDB Act, see the relevant rules, and also see the privacy policy of individual apps that you use.
Sir, but still many online frauds are going on. Like in a recent in my neighborhood, one person who's a well-known officer in bank, still his all account has hacked. So and he is in depression now.
No.
So how could we
See, that
stop
is
this?
that is a crime. It's like saying we have got IPC, we got CRPC, but yet a murder will take place, a crime will take place, theft will take place. For that, there is no solution. There will always be some rogue people who will violate the law. For which cyber crime is there. I'm talking of normal civil. You are a lady, you got your bank accounts, you're on Facebook, you're on Google, etc. So when you interact with people, your information is necessarily going through various computers. Some of it is stored, some of it is not stored. What the right to privacy will decide is what part of the information can be shared, what cannot be shared. For example, in WhatsApp is end-to-end encrypted. What you speak on WhatsApp cannot be known to anybody, can never be understood to anybody. Suppose you send a video also to, say, your father or mother, whatever you're reacting with them on that video will not be known to anybody because end-to-end encrypted. Some things are not end-to-end encrypted. For example, when I speak to you on the ordinary mobile phone, if it's not on WhatsApp, then there is nothing to prevent it from being recorded or not. But if it's within WhatsApp, it can't be. So it depends on the app. So please don't confuse between a hacked crime or a person who has broken into your code and stolen your money. That will be a crime which will be punished. The main argument is information which is has to be shared. Whether you want to use Uber or you want to use Swiggy, you will have to share the information. How much of it can be shared or not. For example, if you're frequently ordering, say, South Indian food, then they may give you on your internet various South Indian restaurants because they feel this is your profile, that you like a person who likes South Indian food. You will get that. Now that when you sign up to Swiggy, the privacy policy will say that Swiggy will share your information with somebody. Now it's up to you to choose to accept it or not. That's what Justice Nariman says. Once you willingly give the information, you can't complain.
Okay, sir. Thank you so much.
Well, thank you very much, sir. One of my question has been answered by sir in this. So, anybody else wants to interact with Arvind, sir? You can directly ask.
Sir, I'm Rajesh Sharma.
Yeah.
Hello. This is my question is about what is voluntary. You just talk about voluntary information. So how we will define the voluntary information? Means if I have my photo on Facebook and someone fetch it and just put it on or share it on other site. So is it not a violation of right to privacy?
No, it is not. You see, it's up to you what you want to share on Facebook. Suppose you start sharing on Facebook your very detailed personal details. Now, if that is going to go to, I'm not on Facebook or I'm not on any social media, so I don't know how Facebook operates. But if you're, from what I see, which I've heard the cases in court, if you're going to send there's some birthday function or some personal function, you share your photographs with somebody. Now, once you put it into the world, you voluntarily put it in, and Facebook will tell you to what extent information will be shared, will not be shared. So once you know that what is going to be shared and you put that information, then that's it. You can't complain about it. Like, I'm not on Facebook, so most of my information will not be known to anybody. But once you go on Facebook, you get the advantage of Facebook. But the minus point is necessarily your information will go. And again, the plus point is you may get a lot of notifications, advertisements, which will meet your requirements.
Thank you, sir.
Well, thank you. Anybody else wants to? I think Mr. Gandhi was raising his hand.
Good morning, sir.
Yeah.
So recently, as we know that Indian Parliament has passed a personal data protection law, and it is, one can say, it fulfills all the principles of data protection, like data minimization, as the government is saying that all the principles of data protections are being fulfilled which have been conceived in European GDPR. But sir, difference that we see through European GDPR is that European GDPR is talking about protecting rights of individual in comparison to transnational movement of data. But when it comes to Indian DPDP Act, it is focusing more on data protectionism and putting data inside the country and locating servers inside. So my question would be that, do you think Indian DPDP Act, when it comes to globalization and other phenomena, will it be good enough to cater the problems that will be brought up by new digitalizations and technologies like AI coming up?
Yeah. Now, one thing as far as the European GDPR is concerned, that is very, very restrictive. And European GDPR is only in 27 countries of the European Union. Most of the world don't have such restrictive provisions as the European Union. There was a PIL where I was also appearing, where they wanted India to adopt GDPR. And we said it's for Indian Parliament to do so. Our needs are different. Singapore has got its own, the whole world except Europe has got a certain rule on privacy, which we also follow. So India considered GDPR, and this PDP bill, which had numerous discussions, it had a number of drafts, there's a Sri Krishna committee and so on and so forth. With great discussion, deliberation, now they've prepared the thing to suit Indian conditions. So the basic objection to include European restrictions was objected to. That matter is still pending, because we say that it's for Parliament to decide to what extent you go. You see, there's always a conflict. There are a huge amount of benefits, and these benefits have got a downside where the information can be shared. It's like, say, for example, the more the number of vehicles, more people have got easy movement, but that is accompanied by higher pollution. So every benefit has got a negative point here. So you've got so many benefits through internet, but one downside could be the information can be shared, your details can be known to so many people. How to protect it is what the PDP Act tries to do. And this is going to be a perennial problem, because you have to balance between the benefits which you get from the internet against the downside or against the defect minus points of that. So it's always a balancing act to what extent you go. Because if you have too many restrictions, the internet will not be beneficial. If you have too much of freedom, information is violated. So PDP Act in India, in the US and Singapore and Japan, all over the world, they have done a balancing act. Europe has gone more towards protecting privacy. So there the internet facilities are much lesser than what are there in the other countries.
Sir, one more follow-up question. One more small follow-up question. So, when it comes to particularly implementation of new AI Act, you must have witnessed that AI Act divides algorithms in high risk and low risk algorithms, but Indian ecosystem does not have any kind of discussion in that regard. So what I'm trying my question would be to you is that, if when it comes to high risk, where our profiling can be done by policing agencies for the purpose of predicting crime, or in that way other technologies that can be used for taking away the rights, do you think, in your personal opinion, that DPDP Act is good enough to safeguard all these rights? Or do you think that we need to have a mechanism, a specialized mechanism, to address the rights that are attached or that will be impacted by the new technologies or the rise of new technologies?
Well, obviously, Mr. Gandhi, you know a lot about data protection and so on. I have not seen the interaction between artificial intelligence with PDP Act. I don't know whether that has been discussed fully in the PDP Act or not. Frankly, I'm not able to answer a question because I have not really studied high-risk algorithms, low-risk algorithms. So you must pardon me. What I was involved in was basically information sharing in WhatsApp, Facebook, and so on and so forth. To what extent it can be shared, to what extent data can be stored, to what extent data has to be deleted. And these are the basic issues. But now AI is a completely different thing, whether AI can be used. See, because AI itself is nothing to do with information. AI can be used for data mining or for analyzing information. You get millions and millions of bits of data. AI, correct me if I'm wrong, but what my understanding as a layperson is, AI can be used to sift the data and make numerous inferences. What is what kind of food this person likes? What kind of attitude this person has? Is he likely to commit a crime? That could be the inferences done by AI. So to what extent it can be shared, I'm not really in a position to start. But definitely this is a point which I would also like to read on. That is high risk and low risk algorithms and artificial intelligence. But I'm glad that you have much of research on PDP. I wish you all the best.
Thank you so much, sir. Thank you so much. I got the point that I need to incorporate now.
Yeah.
Thank you, sir.
Is anybody else wants to interact with Arvind, sir? There's a question which I'm seeing, sir, that somebody wants to ask the 3 dimension as you just told.
Yeah,
You can,
they can note down if it's physical privacy, informational privacy, and decisional autonomy.
Does anybody? I think Amrita wants to ask. Amrita, you can directly interact with sir.
Good morning, sir. I just want to know about the third part. What is that? Can you explain me? I am not able to understand.
Physical privacy, information privacy, and the last is decisional autonomy. Autonomy of decision making. You can make your own decision. Whom you want to marry, whom you want to, what career you want to follow, what path you want to choose. So the state can't regulate your life because you are free to make whatever decisions you want. For example, in the case of disclosing in your husband's name in the birth certificate, you may choose not to do so. There are so many other decisions you may take, which should is entirely within your decision. But it will substantially apply in the case of marriage, in the case of adoption, and so on and so forth, where it's up to you to decide how you lead your life. Decisional autonomy of decision making.
No, by that examples, I understand what does the term mean. Thank you so much.
Anybody else? If any of the participant wants to interact, they can directly interact to sir. So, sir, as there was a question in anticipation. So, somebody asked me, who's very fond of this nicely written book, that you have compared the 10,000 rule. So, sir, all as a practically, sir, since you have a huge experience at the bar, so all what we do is practice, and this rule means practice. So, sir, as your experience at the bar, how relevant or how forceful it should be, or it should be a predominance objective to a student of law who really want to explore in the field of law.
You see, first of all, this 10,000 hour rule does not mean that if you keep practicing for 10,000 hours, you'll reach the top. That's not the correct meaning of 10,000. For example, you can keep playing cricket for 10,000 hours, but doesn't mean you'll reach test level. What that really means is, because it is done by Anders Ericsson, it means 10,000 hours of deliberate practice. Now, what is deliberate practice? That is, you practice, you get a feedback, and you constantly keep on improving. Like suppose, for example, if it's a bodybuilding, you keep on lifting 5 kilos of dumbbells or doing just 2 kilometers of treadmill, you can keep walking all your life. You're never going to reach any level. But if you keep on increasing the intensity, increasing the faith, for example, if you're a lawyer, if you're, say, studying, say, constitutional law or some law, then you have to keep on getting a feedback. Am I learning more? Am I getting to a different level? Not just simply, see, all of us, so many of us will practice for 40 years. Suppose you practice for 40 years and there is, say, for example, you have, let us say, 250 hours of practice per year, then all of us finish 10,000 hours. If you practice, now how much? If you're working, say, 6 hours a day, then you will finish your 10,000 hours in 5 years, you'll finish 10,000 hours. But you'll be in the same position. You may not have getting a better practice. Why? Because you're not analyzed. How am I improving? So 10,000 hours of deliberate practice is to constantly improve. And when he says that, say, for example, a piano player or a sitar player or a musician person, they have constant feedback. How am I doing? Am I getting to a better level? Am I getting to a better level? So 10,000 hours is just not 10,000 hours of deliberate practice. Practice with feedback where you keep on improving on a daily basis.
Well, thank you very much, sir. Anybody else wants to interact? Anybody wants to ask any? I think Pulak sir is there. Sir, I think you have a query.
We had a very educational experience with what you've said, and we look forward that sometimes something on GST, if some seminar can be held on GST, because those are the very shooting problems which we are facing on day-to-day basis.
See, the whole difficulty is I'm doing mainly work in Delhi, so I'm not on a daily problems, because for GST what happens is these seminars on GST, should be done with people who are practicing before the AR tribunals and so on, who are dealing with the daily current matters.
Correct.
By the time the matter comes to us in Delhi, 4-5 years have passed. So what
I know.
is already over now. The new problem has started.
I know. But are you doing some research on the? No.
No, I'm just in part of the advisory council on GST, where we keep making suggestions on what changes can be made. So people give us feedback that this rule is creating a problem, this notification is creating a problem. Then we put it to the Tamil Nadu government for putting it to GST council. These are the hardships. For example, people in the auto component sector have got this difficulty, or people in the soft drinks industry have got this problem, or this lacuna is there, this complication is there. We put it across to the India.
Thank
So
you.
anybody else wants to interact? Pulak sir, I have just requested to Arvind sir, and he has promised that he will plan next year, probably after Holi.
We'll appreciate and we'll look forward to.
After next year or 25 or 24
or 25. That is again a 2 years.
Yeah, no, because a lot of plans are already 24. Already most of the plans have been made. So yeah.
So now I call upon Mr. Amanjot Chadda. Sir, we have a small group which is known as We the Lawyers at Nainital High Court. So what we are doing, we are calling great luminaries as you are before us. We used to call, Mr. KTS Tulsi was with us as a speaker. Justice Ranganathan was with us. And we are periodically calling senior advocates because we have a young group and a new bar. So we have one prominent member, Mr. Amanjot, and he will say the vote of thanks, and thereafter we'll wrap up the session. Now, Amanjot, over to you.
Thank you so much, Shakti Bhaiya. Ladies and gentlemen, members of the bar, and my dear law students, it is with great honor that we gather here today to recognize and acknowledge the exemplary contributions of Senior Advocate Arvind P.Datar, a distinguished legal luminary whose profound arguments significantly impacted the landmark case of Justice Puttaswamy versus Union of India in the Supreme Court of India. Senior Advocate Datar's unparalleled expertise and eloquence in presenting the case surrounding the right to privacy have not only shaped the discourse on fundamental rights, but also paved the way for a more robust understanding of privacy laws in the country. Today, we all gather here to pay our tribute to his profound legal acumen and unwavering commitment to safeguarding individual liberties. Senior Advocate Datar highlighted the cases of MP Sharma versus Satish Chandra, which was an 8-judge bench, and thereafter Khadak Singh, which highlighted that the government's stand was that India doesn't have a right to privacy. Thereafter, he told us about the right to privacy and how it is following in entire Part 3 of the Constitution of India and is just not restricted to Article 14 and Article 21. Thereafter, he told us how the law developed in the US. He also dealt with Indian cases, especially the Selvi, which was about lie detector test, and Mr. X, in which HIV status of a patient was disclosed to his fiancé. Thereafter, Senior Advocate Datar told us about the 3 dimensions of privacy which are dealt by Justice Rohinton Nariman in his judgment, which are physical privacy, informational privacy, and decisional autonomy. Thereafter, Senior Advocate Datar sir highlighted the cases in which this reasoning was used, namely Anuradha Bhasin, which was about Kashmir internet shutdown. Senior Advocate Datar has done entire research in right to privacy and has held this 9-judge bench, which is there with us. His arguments have helped the court and even the students and the lawyers to understand what the right to privacy means in Indian context. Senior Advocate Arvind Datar's erudition, dedication, and unparalleled expertise in constitutional and taxational laws have significantly shaped the legal landscape of our nation. His insightful advocacy and meticulous legal reasoning in this landmark case have set remarkable precedents and fortified the foundation of privacy rights for every Indian citizen. Today, we gather to acknowledge his remarkable efforts and legal prowess. Let us extend our heartfelt gratitude and appreciation for Senior Advocate Arvind P. Datar in joining this conversation with us and letting us know his views. Thank you so much.
Oh, thank you, sir. Just 1 minute more, sir. This whole session is never been completed if without the help of Vasudev College of Law, Haldwani. And sir, we have with us Assistant Professor Mr. Abhimanyu Gandhi. And sir, the point to be noted, he was just presented his dissertation on artificial intelligence, and his paper was awarded handsomely. So, Mr. Gandhi, I request you that on behalf of Vasudev College of Law, say a few words, and then we will immediately wrap up the session. So I think he was arranging in the classrooms because 2-3 classrooms are live to this session.
Okay. Doesn't matter. Wish you all the best. Thank you so much.
Thank you very much, sir. Thank you very much. Thank you.